Ugo Parente was born in 1982. When he was only 8 years old, however, his mother passed away. Although he overcame this great adversity, Ugo excelled at school and was Darks and school captain of his year. He was also a vocal anti-drug campaigner, and finally, after being admitted as a lawyer in 2006, he landed a job at a renowned law firm. However, Ugo's life went downhill after he split with his partner of 5 years in 2010. Shortly after this, he developed a drinking problem and eventually a drug addiction in 2014. On Friday the 26th of June 2015, Ugo had his car stopped and searched by police in Mascot. They found a plastic bag containing 100 MDMA tablets, along with 2 other drugs, all in trafficable quantities. He was convicted under the Drug Misuse and Trafficking Act for supplying all 3 drugs and sentenced to 4 years imprisonment. The Law Society sought declarations that Parente is guilty of professional misconduct, is not of good fame and character, is not a fit and proper person, should be removed from the role, and should pay the Society's costs. The court found that it was not necessary nor appropriate to make the first 2 declarations, but made declarations in favour of the last 3 orders. Baston and Ma emphasize that the legal profession is subject to the highest standards of integrity. Therefore, whether Parente was not a fit and proper person, and hence should be struck off the roll, turned on whether the community or the court could trust him as a person of integrity. The judges were quick to find that someone who had been convicted of supplying prohibited drugs could no longer be trusted as such a person. However, a lawyer should only be struck off the roll if the reason for disqualification is permanent or at least of indefinite duration. Here, although a forensic psychiatrist had given evidence of Parente's rehabilitation, the judges ultimately concluded that there was insignificant evidence for them to be sure that his drug addiction would not make him a fit and proper person upon his release from prison. Brereton argued that whether Parente should be struck off the roll depends on whether allowing him to continue to practice would undermine public confidence in the legal profession. He concluded that allowing Parente to remain on the roll would damage the profession's reputation, given the serious nature of his crime. Also, Ugo's failure to appear in court and attest to his rehabilitated state also led Brereton to doubt whether he would be fit to practice after being released from prison. Parente's decision to supply drugs is better viewed as a slippery slope than as a product of an ethical blind spot. It is plainly clear, especially from the point of view of a lawyer, that supplying drugs is unethical. However, although he likely knew it was morally wrong, his desire to escape the emotional trauma of his breakup, the stresses from work, as well as to feed his addiction, likely overcame his own ethical standards. Once he had gone down this slippery slope, making ethical decisions had gone out the window for Ugo. Secondly, another important thing to notice about Parente's behavior was his decision not to appear in court. This was likely influenced by the following: the shame and embarrassment he felt, his lack of desire to remain on the roll and continue practicing as a lawyer, as evinced from his lackluster efforts at work, which eventually got him fired, and the likelihood that he was still likely depressed, although he had beaten his drug addiction.
The key ethics issue at the heart of the case was Parente's professional misconduct around whether he failed his paramount duty to the court as an administrator of justice. Now, normally, professional misconduct can be difficult to measure, but as Jonathan has mentioned previously, Section 297 of the Legal Professional Uniform Law can offer us some clarity around the area, particularly the focus on whether Parente was a fit and proper person despite being found to be a user and, most importantly, a dealer of illegal substances. Ultimately, the decision was made on how it is currently, not how it could be, or based on the past evidence. The question then becomes whether the reputation of the profession is beyond the capacity to forgive those who do the time, but never seem to receive the clean slate they are promised, as they continue to be condemned post-crime. Is this truly right? I'll pass it on to Aoife, who will be exploring this key question further.
The Court of Appeal weighed numerous mitigating factors against the gravity of Mr. Parente's offences to determine that he was not fit and proper to remain on the roll of Australian lawyers, as he was not of sufficient fame and character. But what does that really mean? These concepts have not been given a clear and definite explanation by the courts, and thus remain malleable in the hands of individual judges. Baston, Meagher and Brereton accepted the contention that, despite his criminal conduct, Mr. Parente was otherwise of excellent character. They cited evidence indicating his performance during high school, dedication to the legal profession, and campaigns against drug use. Similarly, subsequent to being charged, Parente showed genuine remorse, ceased drug use, and was compliant with treatment. He was honest and cooperative with the police investigations, pleaded guilty in court, and was a well-behaved inmate. However, the court also had to consider the criminal conduct itself. Justice Brereton argued that his lapse was great, as his drug dealing was premeditated and contributed to the ruination of others' lives by leading them down the path to addiction. This assessment of character must be considered in light of the objective of ensuring fitness to serve in the legal profession. Was removal necessary to protect the public and maintain the integrity of the profession, or would it simply operate as further punishment? The decline in Parente's work, which culminated in termination, was an important element of the reasoning of the court. Although Brereton determined that Parente would no longer pose a risk to clients if he were allowed to continue his practice, there was also the consideration of the reputation of the legal profession. The court asserted that conduct of Parente was such that it involved a significant amount of public disgrace, and it would likely make it difficult for others to associate with him in a professional capacity. However, Baston and Meagher also acknowledged that Parente's derelictions were consequences of his addiction. Brereton highlighted that the legal profession often tolerates a single lapse when individuals are of otherwise good character. Although Parente's offences were serious, they took place against a backdrop of addiction and depression, and the court accepted he was unlikely to re-offend. The court recognised that Parente felt remorse and shame, accepted responsibility, was working to better himself, and had otherwise demonstrated excellent character, and yet he was still removed from the role. Was this fair? This instance arguably exposes the potentially arbitrary and inconsistent applications of fame and character. The wide discretion they allow may be incongruous with the stability and consistency of legal concepts, abrogating the rule of law. There does appear to be an element of dissatisfaction evident in the obiter of the judges. Justice Brereton remarked that the decline and fall of the respondent Ugo Parente bears the hallmarks of tragedy. Baston and Meagher suggests that the mitigating factors may have indicated that Parente would be suitable for readmission in future if he had presented sufficient evidence. This was reflected by Justice Brereton's assertion that he could not conclude that Parente should not be removed absent any evidence from him. The court highlighted the lack of evidence from Parente despite the onus being on the claimant. Perhaps the court was not willing to challenge the Law Society's application for removal when Parente himself was also unwilling to do so. Keeping in mind that the integrity of Parente formed the basis of the ethical conflict, it appears that the judicial officers were utilising their broad discretionary power to prioritise the protection of the profession rather than the individual legal practitioner. However, from the perspective of Parente, the decision may be perceived as unfair, as a complex web of mitigating and aggravating circumstances were evaluated using the ill-defined concept of a fit and proper person. Ultimately, broad discretion arguably serves utilitarian purpose by enabling judicial officers to make nuanced decisions about admission to protect the whole profession, but this process may need to be refined to promote greater consistency.
When we compare the current case with those studied in the course, we can see that there is a wide application by the courts as to what consists of good fame and character. Adverse findings of fame and character are not always in relation to the improper practice of law or even from criminal convictions. Courts have emphasized in Zeem's case that there must always be an inquiry as to whether the lawyer should be struck off, even when they have been convicted of a serious criminal offense. However, lawful acts involving a degree of dishonesty have often compelled the courts to refuse admission or to strike individuals off from the roll. For example, the candid disclosure of 2 counts of past academic misconduct in reapplication by Gills was sufficient to prove that he was of good fame and character, despite the acts only having occurred 4 years prior. In comparison, OG was refused admission in his case for failing to disclose an earlier incident of collusion in his application to the Law Society. courts have previously found that external stresses may justify errors of judgment. In Del Castillo, the applicant was charged, whereby he was found to have been dishonest to police and gave false instructions to his lawyer. However, he was ultimately acquitted. Although he did not disclose this previous charge, the court accepted that his dishonest actions were influenced by extreme external stress, whereby he was acting in a state of panic after a death had occurred. However, in the present case, Parente's actions could have been brought by his external influences following the breakdown of a long-term relationship and the subsequent depression and addiction. However, due to the harm that he had brought upon his clients and other members of the public, external factors were not sufficient to justify his conduct. Similarly, harm to others have been examined in Prothentary of the Supreme Court and P. P's case presents similar circumstances to Parente's case, whereby P, a solicitor, was convicted and sentenced over possession of a trafficable quantity of cocaine. However, she was not struck off the roll. Why was Parente struck off then? The main reasoning presented by the court was due to the differences in circumstances. P was found with only a relatively small quantity of drugs, which would have negated the supply to others for financial gain, and his sentence was shorter in comparison. Therefore, she was not found to be harmful to others and allowed to remain on the roll.
Parente's decision to supply drugs was the major catalyst for his removal from the role. In order to assess whether and how the use of an ethics decision-making framework could have helped Parente to manage his issues and decide not to sell drugs, Parente's own personal use of drugs must always be kept in mind. Once Parente was gripped by drug addiction, it is highly unlikely that an ethics-based decision-making framework, such as Reston-Breaky's 6-step model, could have been used by the complainant to better manage his issues and make ethical decisions. Drug use creates a narrow tunnel vision that inhibits moral sensitivity, impairs reasoning processes, and distorts the professional's moral motives and character by heightening the perceived urgency of non-moral factors. As a result of this urgency, key enablers in Reston-Breaky's model were eroded for Parente. For example, his moral sensitivity was affected by drugs as his attention was diverted towards the maintenance of addiction. If Parente had used Reston-Breaky's model before he decided to cope with stress via illicit substances, the complainant could have better managed his issues so that he did not have to resort to drug supply. The model would have proved most useful during the judgment, decision-making, and action stages. Parente needed to draw on his moral reflectiveness to uncover alternative courses of action to cope with his mental health issues. According to Reston-Breaky, the best way to support those in the legal field struggling with mental health is to have highly visible and specialized institutions that help lawyers create work-life balance, enhance their quality of work, and support their general well-being. If Parente had engaged with available institutions such as law care, his ability to morally reflect could have been better cared for and consequently would have flourished when faced with the decision to use drugs. Parente did have the necessary moral motives to make morally correct decisions. However, the complainant did not protect these motives against potential ethical dilemmas. As Reston-Breaky suggests, the complainant could have written down his ethical boundaries at the beginning of his career, setting a clear line that he would not cross in later life. This would have better prepared the complainant to make an ethical decision when faced with personal emotional conflict. Though Parente may have known his judgments and decisions were unethical, he was not confident enough to act in line with his moral character because of the intense nature of the emotional issues he was facing and perhaps the stigma surrounding male expression of emotional distress. Reston-Breaky argue that moral character needs to be facilitated throughout a lawyer's career by strong interpersonal networks. The complainant's workplace failed Parente in this respect by terminating his employment instead of facilitating mental health care when Parente's performance reached unprecedented lows. It should be noted that the complainant did successfully partake in review. He made efforts to better his decision-making once he was arrested and convicted by participating in rehabilitation and expressing genuine remorse for his actions. However, the complainant would have benefited from this review if he had assessed his decisions much earlier.